Bob, have you heard of anything quite like this?
No, Vinny, this is a chaotic defense. First we have, let's not forget the son calling in saying she fell on a knife, so we have an accident. Then we have an alternative theory that this was some sort of self-defense, again, perhaps set up by the grandmother, who has a motive, who also indicated that the victim was in fact afraid of her son. And now you have this suicide by son, which I think is ludicrous. And I think the jury is going to see that for exactly what it is. Not to also forget about the fact that we have a medical examiner testimony that's declared this to be a homicide because the stab wound itself is not one that's consistent with an individual who commits suicide. In fact, the grandmother has shown us one very important thing. When she wants to try to kill herself, which may be because she's got a maniac for her son, she does it with the use of drugs and alcohol, not by trying to get somebody to stab her in the neck. It's to me, the defense is ludicrous. And I think the defendant, actually, the defense attorney, I agree with Ann, hurt herself by giving so many alternate theories in the case. The jury's going to see right through it.
Now, we heard from Grandma, Rick. Let's take a listen to what Grandpa has to say about Collin.
Did it appear that the defendant trusted you and would talk to you and confide in you about certain things, grandfather, grandson topics?
Yes.
Did there come a time when the defendant said something to you that was very disturbing to you?
Yes.
Tell the jury about what the defendant said to you.
My grandson was very aggravated at his grandmother and his mother. He said, "I am so tired of these two bitches. I'm disgusted." He said, "My mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life and the blood leaving her body."
Now, when he said that, what went through your mind?
I needed to take a deep breath and do what I could to discourage that thought, because thoughts become words, words become actions.
What did you say to him in response?
I said, "Collin, I love you, buddy, but you can't have those kinds of thoughts." And I was afraid it would actually give her nightmares.
Did you tell her a clean version or a more vanilla version, if you will?
Yes, I did.
What was her response?
That he's been threatening her and he's been threatening Susan multiple times with killing both of them.
Okay, so Grandma and Grandpa aren't together anymore. They've separated for years, but who's more credible? Because I think these are two crucial witnesses. Grandma versus Grandpa. Bob, I mean, these are completely different approaches to what happened here. You know, suicide versus cold-blooded murder. That is scary. If your grandson is saying that, that's absolutely scary, especially in light of the fact that he has shot and killed his father also.
Yeah, Vinny, I think you're bringing up the point that when a judge is charging the jury, the judge says when you're trying to determine the credibility of the witness, what do? We look at whether their story makes sense. We look to see whether there's any objective evidence that either proves or disproves what the witness is saying. Here, you have the grandfather giving you the story, and you have the grandmother giving an opposite story. But we also have a previous incident that's on body cam where the defendant is literally saying, "I'm in constant fear, flight or fight, and if she's going to do something, I don't think I'm going to act out. Everybody thinks I'm psychotic, that I want to, kill her." And he basically says through that, "Well, I don't know." So that's a weird comment for him to make. So it's clear the jury hears that he's got a problematic issue with her. You have the other 404 evidence that came out with respect to the death of the father under those nefarious circumstances. You have the medical examiner that's saying that the defense's story doesn't hold water. So when you're looking at all the various points of light, and let's not forget his 911 call, he's not saying suicide. He's not saying it's an accident. He said, "We had a 2-hour-long fight. I've had a very, very long fight with mom, and she fell on a knife and is bleeding from the neck." It doesn't sound like suicide to me. In my opinion, that's the end of the story in terms of whose credibility you're going to believe between the grandfather and the grandmother, because it's clear that even his own words, his own actions, body cam, and on the day that it happened, support the grandfather's version that the kid's a psycho.
Yeah. The jury is still out. Bob, I want to start with you as former head prosecutor. If you're in Oklahoma and you're looking at what's happening down here in Florida, does any of this impact the decision on what you do with the case that was already not prosecuted for the death of his father?
Yeah, Vinny, of course. I mean, under those circumstances, thankfully, I've never been in this situation. I would have to reevaluate, especially because there were discrepancies in the evidence. And to me, the way we used to be is that every case, unless we could prove it was an accident or it was a suicide or a medical event, was a homicide unless we could prove otherwise. And that doesn't necessarily mean we have to charge. But these guys made an affirmative decision not to charge. Now they have to reverse engineer that decision, which is likely to be admitted as evidence during the course of the trial if they were to recharge him under these circumstances, having previously concluded that it was a matter of self-defense. That's a place no prosecutor wants to be. But by the same token, I don't think after the evidence that came out in this case, I could just turn a blind eye to it. So I'd have to reevaluate the evidence, see where the discrepancies are. And, you know, sometimes, Vinny, if you really believe a person did it, sometimes you charge them and you try the case, and if you lose it, you fight the good fight, then you lost it. Sometimes it has to be that way. Something else I just note, you asked before about the credibility of the other witnesses. Don't forget that in this particular case, the one that we're talking about right now that we're discussing, the text message that the mother had sent about exposing the fact that it was really a murder of the father as opposed to an accident is one of the motives the prosecution says as to why he killed the mother. So there's some issues there with regard to whether or not that may be admitted because now she's gone, so she can't be cross-examined. I'd have to look at all the evidence rules. I'd have to look at that very significant text by the mother to see whether or not it could be admitted and whether I want to take the chance of charging him. If I really believed in my heart, you asked me when I was the head prosecutor, if I had believed that, in fact, we made a mistake and it was a murder and not a self-defense, I'd charge it and I tell my APs, go in with your head held high, try the fight. Fight the fight. If you lose, not a problem. We're doing the right thing here.